Thank you very much, Your Honor. Your Honor, I will defer to the motion for full argument, but there are some highlights I'd like to make at this time during oral argument. And the most important, Your Honor, is that in this complaint, if you refer to the statement of facts, the statement of facts state that a response worker and the police were attempting to serve Ruth and Isael with a court summons for the care and protection order. Your Honor, in addition to that, it states down below that the response worker had been instructed by Mr. Rivera to leave the summons in the mailbox, and that Mr. Rivera was made aware of what the summons was for, and he also made it known by text messages that he would show up for court. Your Honor, in this court's decision, this court also referred to a summons being presented to Mr. Rivera. And Your Honor, I have provided a copy to the district attorney. Our motion requests that this court take judicial notice of what a juvenile court summons is. And in the juvenile court summons, we ask for judicial notice because it's a form approved by the Chief Justice of the court. It's a standard form used in all, just like similar, very similar, almost exact to what the district court uses for arraignments. It doesn't convey a past order. It just notifies a party to appear in court at a certain date and time. And so, Your Honor, if I may submit to the court, I have a copy of the summons.
Any objection?
No objection, Your Honor.
Well, I guess my question is, how is this relevant to my determination when my job is to determine if there was probable cause based on what was attached to the application of complaint to the clerk magistrate? So me considering evidence that was not available or considered by the clerk magistrate to me doesn't seem relevant to the decision that I'm making. Maybe relevant to whether or not the charge ultimately can be proved, and I don't disagree with that. But my review is limited strictly to the four corners of the application, and if there was a show cause hearing, which here there was not, to what the clerk magistrate was able to review to determine probable causes. So this is information that wasn't presented and therefore is not considered. So I don't know why I should consider it now.
Your Honor, because the court's decision on the original motion to dismiss makes the conclusion that Mr. Rivera was aware that that custody had been granted to the department because he was aware of a summons.
Well, counsel, what you read into the record was not the full sentence. It says a care and protection order that had been filed with the Fitchburg District Court on the 26th of February, where DCF was granted custody of the 5 children, and they list them. Then it said DCF was then serving him with, which is referring to what was outlined above, and what was inside that summons. It may or may not be accurate that that information that's in the statement of facts, but it says they made him aware with a court summons for the care and protection order and to take custody of the children. So that's what's stated in there. Whether or not it actually appeared in the summons is a different question, because the clerk magistrate didn't have the summons. It wasn't presented, but what it does say is the day prior, and again, it may or may not be factually true, but it is what was presented to the clerk magistrate. The clerk magistrate is not going to go and research whether or not a care and protection order was issued the day prior. They have to make the determination based on what is in the application. So it says that the department did have custody, that an order was issued the day prior. It says that the response worker along with the police were presented there and attempting to serve them with the court summons regarding that care and protection, where the court already took custody, and to take custody of the children. So to presume then, where it goes on to say that Mr. Rivera was made aware of what the summons was for and about to me indicates that the court had taken custody and issued an order, and they were there to take custody of the children. For and about.
Sure, Your Honor.
So that's what the clerk magistrate had to work with. not the fact that that may not have been in the summons, but that's what is inferred by the for and about, the paragraph prior to where you started reading, where there was an actual order of the court removing custody from your client, and they were there to get the children.
Yes, Your Honor.
So you can only assume that that's what the worker is communicating, or
Right.
that's what he infers he's communicating, to serve the summons, but also tell him what it was about.
But nowhere in the statement of facts, Your Honor, does it assert that any authority informed Mr. Rivera in any manner that custody had been given to the department.
Oh, I disagree. I
That-
think where it says that the order had been issued and custody was transferred to DCF and he was telling him what it was for and about, I think that is an authority giving him notice of what it's about.
We don't know how he was told, we don't know who told him, there's no, our position is, Your Honor, they're referring to the summons that they were there to serve, attempt to serve, that they didn't serve. And so, it just, for us, it falls short of establishing probable cause that he knew that the department had custody. They don't state that and Your Honor, there is no order in juvenile court either when a department's giving custody. It's minimus, similar to the district court, that commits someone to the department. No service is required of that. It does not allege any facts that he was aware, and Your Honor, matter of fact, it does state numerous times that Ruth was made known, that some unknown person at an unknown time was going to take custody, that DCF would take custody of these children, but it does not avert that fact in regards to Mr. Rivera. And Your Honor, let me just. Yeah, and Your Honor, I don't need to go very far into this because I know the court is well aware of the standards of probable cause, but from the defense's perspective, Your Honor, Mr. Rivera being aware is a conclusion. It's a suspicion. There's no facts to support that he was aware of this custody order. Matter of fact, there's facts to show that that they weren't at the property and they hadn't been at the property there. So how would he have been made aware that DCF had custody? That falls short of probable cause.
Okay, I appreciate that. Anything else?
Do you want me to go into some of the other arguments, Your Honor?
Go into whatever you
Thank
want.
you. Thank you. The other thing that, Your Honor, the motion argues is that there's no probable cause before the statement of facts were filed that Mr. Rivera was even with these children. The statement of facts, Your Honor, assert that the phones were pinged, however, they were off. The statement of facts, Your Honor, state that a car was observed, a license plate was read, I believe in Fitchburg, and then a car was spotted that allegedly Mr. Carcione was driving. There's just, again, Your Honor, no probable cause to show that Mr. Rivera was even with these children at the time that these statement of facts had been filed. It's again, Your Honor, the statement of facts are very conclusory. They state the defendant is believed to be with Ruth and the children. Believed by who? Believed how? Why? That's not probable cause, that's a conclusion. And we don't even know who made that conclusion. And Your Honor, just again for the record, I just want to state that the statement of facts state that the Fitchburg District Court issued a custody order, and obviously this Fitchburg District Court did not issue a custody order, it's juvenile court. Yeah, so, Your Honor, just back to my argument about how the suspicion is not enough to rise to the level of probable cause. There's just so many statements. Isael was made aware of what the summons was for. None of the statements identify who made them, who believes it, who knows it, or what those knowledge was based on, what facts, who made known these allegations. But really, Your Honor, I just want to drill in that the statement of facts just fails to state directly that anyone informed Mr. Rivera that the DCF had custody. And they would have, they did it for Ruth. It's very, I think, Your Honor, it just falls short of establishing probable cause. But I think, Your Honor, the most important point is that we wanted to ensure that the court and that this motion was based on a correct understanding of what a summons actually was. Even if Mr. Rivera, I read this quite differently, Your Honor, than Your Honor does. That he was made aware of what the summons was for, about, that to me I read, yeah, he was made aware that there was a court date. That's what the summons was for and about. So I read that differently. I couldn't infer knowledge from that at all.
I understand your argument, counsel, but again, I think you take that in a vacuum, disregarding the prior sentence where they say a care and protection order. And again, I'm not saying that everything in here I agree with is factually correct in the sense that it wasn't the Fitchburg District Court, obviously, would issue a care and protection order. But my determination has to be based on what the clerk magistrate was presented with. Now, had the summons been attached, and maybe their conclusion of probable cause would be different, but the fact that the worker is saying that a care and protection order, or inferring that that order issued, DCF was granted custody of the children, and they were attempting to serve them the care and protection order, right? That's what it says, the summons for the care and protection order, so you can infer above that the order was issued where it's granting custody. That's what it says prior. I don't know if that's true. The magistrate didn't know if that's true. That's what the statement of facts contained, that there was a valid order granting custody to DCF. Then they're saying, we are trying to serve him and tell him what it was for and about. So that, more probably than not, for and about means DCF was granted custody of your children, and we're here to get them, and we're telling you about that. And they obviously had communication, and your client said, leave it in my mailbox. I'm sure they didn't say, hey, we've got a piece of paper here for you, we're gonna leave it in the mailbox. They were there to actually, so they say, take custody of the children. So I'm sure the conversation, which one could infer probably, more likely than not, included conversation of taking custody of the children per the order. So I don't disagree that this summons, had it been attached, may have caused a different outcome. But I cannot now, in hindsight, say, well, the clerk magistrate should have known, should have gone to get, should have investigated what was alleged in the application. That's not their function. It's to determine whether there's probable cause, which is an extremely low standard. Whether or not these can be proved is a completely different animal. So, Commonwealth.
Commonwealth has nothing to say, Your Honor.
But I will review your motion again, and in addition to your argument, and take the matter under advisement.
Thank you, Your Honor.
Thank you, counsel. And I'm not gonna take this as evidence because it was not part of the application for complaint, so I cannot take.
I do believe it's a
additional-
possibility, Your Honor. I apologize, but the documents weren't available on mass courts. It is a possibility that this was filed with the original motion to dismiss anyways.
Well, I
can't-
don't think I necessarily saw that, but it wasn't filed with the application, which
Sure.
was required to be the extent. Commonwealth, anything?
No, Your Honor.
All right, thank you both.
Thank you, Your
Thanks
Honor.
for your patience today.
Your Honor,
Looking for
just-
March 10th for the next date.
Perfect. Thank you.
Thank you, Your Honor.
March 10th. That's the date?
That's
All
what-
rise, please.
Great date, March 10th.
Thank you.